no material has been placed before me to demonstrate the asserted contempt by the Deputy President. I maintain my earlier position that materials ought to be placed before me rather than addressed from the bar. I decline to make any orders respecting the above prayer. I do not see how the presence of police officers jeopardizes the accused's presumption of innocence. I respectfully decline to make any orders on that. To change the reading of the name of the ninth accused person from John Njenga to John Maina Njenga Kamunya. Mr. Ondieki requested the following documents in addition to the statements already supplied. 1. Covering report. 2. Investigation report. And 3. Crime and incident report. And finally, that summons be issued upon His Excellency Rigathi Gachagua, the Deputy President of the Republic of Kenya, to appear before this court. This is over the Council's strong conviction that the Deputy President was making comments which to him amounted to prosecuting this case in public rallies. He submitted that under Article 27(1) of the Constitution, it is provided for equality before the law, and that His Excellency the Deputy President is subject to the law, and there is need that he be restrained from prosecuting this case before the media. The learned counsel submitted that whereas it is provided for freedom of speech, the same does not include making vilifying statements or innuendos that injures the reputation of others with a strong reference to the accused persons herein. The Council made further reference to Article 48 of the Constitution that provides for access to justice. It took issue with the presence of police officers around the court premises and surroundings whenever this case comes up. It stated that this alone harass the accused persons and consequently taking away the right of presumption of innocence upon the accused persons. He called that the Deputy President be specifically restrained from making comments on the case herein. He handed over to his colleague, Mr. Biko, who made application for release of motor vehicles. This was via application dated 14th June 2023. This being a formal application, the prayers were as follows. Prayer 1 was spent. Prayer 2, that the court be pleased to order the respondent and their agents to release their motor vehicles registration numbers KCR 555S, Lexus model LX 570, KAU 831N, Toyota Premio, KAK 628H, Nissan Saloon, KCE 500S, Toyota Land Cruiser, to the applicants upon delivery of identification documents which have already been served upon the state through Mr. Misoi, the investigating officer. 3, that the court be pleased to grant suitable conditions to facilitate compliance and return of vehicles to the applicants in whose custody they were impounded. 4, that the court makes any order it deems expedient in the interest of justice. And finally, that the cost of the application be provided for. The application is supported by the annexed affidavits of John Maina Njenga, Joel Muriu, and Stephen Njenga Maina. The counsel argued largely in in line with the application before he was partially overcome by emotions. He, in the upshot, asked that the application, which no reply had been made by the respondent, be allowed as prayed. The counsel, in furtherance to the application, made an oral application for release of the accused person's national identification cards and phones, which is said were being held by the investigating officer, and made numerous reference to a Mr. Misoi. Let me be clear on this. The applicants in the application are Stephen Njenga Maina, John Maina Njenga, Joel Muru, and Base Limited as first, fourth applicants, and the respondents are the Director of Criminal Investigation, Nakuru, and Director of Public Prosecution as the first and second respondents, respectively. In response, Mr. Omwenga, the learned prosecutor, had this to say: that the application was not served upon the first respondent, hence required more time to respond to that application. On the part of the second respondent, he stated that the document asked for by the learned counsel, Mr. Ondieki, were available and was ready to supply the same. On the issue about summoning the Deputy President, he maintained that no material had been placed before the court demonstrating that His Excellency the Deputy President was discussing the case hearing in public. He asked that the gag orders against him cannot therefore issue. On the release of the motor vehicle, the identification card, he maintained that the same had not been particularized. He stated that, as clearly pointed out, the motor vehicles belong to third parties, hence they ought to be notified before the same are released. He maintained that he was not aware whether the motor vehicles formed part of the exhibits. Mr. Ondieki and Mr. Biko maintained their position in rejoinder. This is the court's considered view. I will make determination in the application. I will make determination in this application in the order they were made and outlined in the 4 of this ruling. I begin with Mr. Ondieki's application calling that His Excellency the Deputy President be summoned before this court to tell the court what is knows respecting this case. As according to the counsel, the Excellency the Deputy President was prosecuting the case in public, a fact refuted by the prosecution. In determining this, it clearly takes me to my directions of 29th of May 2023, when a similar application was made. For clarity, this court has a duty to protect the sanctity of trial and proceedings before it. It is prohibited as a general rule of law comments that would amount to sub judice. The facts of the case ought not to be discussed in any fora than the court. This attracts a punishment by the court where so is established. In this case, I have been called upon to summon the person in the name and form of the Deputy President, Republic of Kenya, who is accused of making comments amounting to sub judice. As I earlier pointed out, in my above referred directions, that is of 29th of May, this court can only give specific order where satisfied that there is indeed a violation. And with a lot of respect, no material has been placed before me to demonstrate the asserted contempt by the Deputy President. I maintain my earlier position that materials ought to be placed before me rather than addressed from the bar. I decline to make any orders respecting the above prayer. On the second limb of the application on release of the motor vehicles, I note that there is no formal response to the application. Oral response can only be permitted only to the extent of the legal points of law, and is a general presumption that issues of fact where no formal response has been raised, the facts are not contested. In this application, I do not find any plausible response by the respondent to this application, despite having been served with the application on 14th of June 2023. Consequently, I give the following directions respecting that application. 1, that the first respondent to within 3 days of today take the necessary documentary evidence respecting the motor vehicles, including but not limited to taking the necessary photographs if need be for purposes of this trial. 2, that the motor vehicles being registration number KCR 555S, KAU 831N, KAK 628H, and KCE 500S be released to the applicants upon presentation of the relevant ownership documents upon the first respondent upon the lapse of 3 days of today. 3, that the motor vehicles above referred should not be disposed of or transferred to third parties during the pendency of this case unless with leave of this court. 4, that the motor vehicle shall be made available as and when it shall be required during the trial, and the second respondent, that is the DPP, should notify the defense of such intention should need arise. That the motor vehicle shall be made available as and when it shall be required during the trial, and the second respondent should notify the defense of such need at least 7 days before the date required. That is all on that application. On the issue of the national identity card and the alleged phone said to be in possession of the first respondent, I direct that a formal application to be made to enable the respondents to make substantive response thereto. For clarity, should the application be made, the same shall be dealt with without requiring the attendance of the accused persons. In furtherance, I direct that the documents requested, being the covering report, investigation report, and the crime incident report, to be supplied to the defense forthwith. On the final request on the item security, whenever this matter comes up, I, with a lot of respect, do not find any merit on that application. I do not see how the presence of police officers jeopardizes the accused presumption of innocence. I respectfully decline to make any orders on that. The prosecution sought leave to amend their charge sheet. The application was motioned through citing of Section 214 of the Criminal Procedure Code. The application is in 2 folds. 1, they seek to effect amendment seeking to invoke the correct date. In this, the learned prosecutor sought to amend, instead of diverse dates from 12th May 2023 to 18th May 2023, to read from 11th May 2023 to 18th May 2023. The charges are to affect count 1, 3, and 4 of the parent charge sheet. The second limb of the intended amendment is to change the reading of the name of the ninth accused person from John Njenga to John Maina Njenga Kamunya. He asked that the application be granted. The application was opposed by the learned counsels for the accused. Mr. Ondieki indicated that Section 214 of the Criminal Procedure Code is to be invoked by the court and not the prosecution, as the case herein. Similarly, the counsel alluded that by granting the application would amount to visiting prejudice upon the accused persons with specific reference to the ninth accused. The counsel took issue with the fact that the ninth accused in the principal charge sheet is proposed to be the first accused in the proposed ends, discriminating against the ninth accused person. This point was reinforced by submissions by Ms. Tamburu. They maintained that the proposed charge sheet would greatly prejudice the accused person. Mr. Ondieki similarly indicated that the proposed amendment would greatly change the form of the particulars of the charge, hence prejudicial to the accused person. He called for the rejection of the application. Mr. Simon Buru submitted further that the prosecution has not informed the court the defect in the present charge sheet, either in form or substance. He asked that, noting that nothing has been demonstrated to the court to warrant the court to exercise its discretion in favor of the prosecution, he too called for the rejection of the application. Mr. Omwenga, the learned prosecutor, reiterated his application on rejoinder. This is the determination. Let me begin by citing Section 214 of the CPC, with which the application is heavily premised. Section 214 provides as follows. Where at any stage of a trial before close of the case for the prosecution, it appears to the court that the charge sheet is defective, either in substance or form, the court may make such order for the alteration of the charge, either by way of amendment of the charge or by substitution or addition of a new charge, as the court thinks necessary to meet the circumstance of the case, provided that, 1. Where the charge sheet is so altered, the court shall thereupon call upon the accused person to plead to the charge so altered. And 2. Where a charge is altered under this subsection, the accused may demand that the witnesses or any of them to be recalled and give their evidence afresh, or be further cross-examined by the accused or his advocate. In the last mentioned event, the prosecution shall have the right to re-examine the witness on matters arising out of further cross-examination. The second limb does not apply in this case. This provision should be read in tandem with Section 134 of the Criminal Procedure Code, which provides that every charge or information shall contain and shall be sufficient if it contains a statement of the specific offense or offenses with which the accused person is charged, together with such particulars as may be necessary for giving reasonable information as to the nature of the offense charged. In this case, The points of suggested and intended amendments have been pointed out by the prosecution to be the names of one of the accused and the particulars of the dates of the alleged offense. What this court ought to guard in such instance is the net effect of granting the application, where it appears to cause prejudice to either of the party. Then the court should outrightly deny such leave. The case herein is in its nursery stage. Indeed, it was coming up for pretrial direction. Not a single witness has been put to stand. This alone extinguishes any possibility of prejudicing the persons charged. It has been submitted by the defense that the principal charge is in conformity with Section 314 of the Criminal Procedure Code. Hence, there is no need to amend. The question that would arise is what prejudice would the intended amendment cause to the accused? To me, the proposed charge sheet would give proper particulars of the charge, which should aid all the parties, including the court, during trial. In the upshot, and in the absence of any potential prejudice to the accused by the intended amendment, I allow the application by the prosecution and consequently grant leave to the prosecution to amend the charge sheet. I reluctantly wish to comment on the fact alluded to by the defense of bringing the ninth accused to be the first accused. I do not wish to make reference to the proverbial horses as put forth by the parties. The net of it is that the appearances of parties in a charge sheet has no connotation to the weight of the charge against the person charged. Let me end it at that. Those are the orders of this court.